paper presenters, and attendees. This is Jithan SB, and I will be a moderator for today's valedictory session. Today, we are all gathered here virtually to bring down the curtain for our 10th international seminar on credibility of evidence by forensic practices in crime investigation, put forward by Kerala Law Academy, Law College, in association with Center for Advanced Legal Studies and Research. Kerala Law Academy, Law College, known as the abode of legal scholars and intellectuals, started its journey under the guidance of late Dr. N. Narayanan Nair sir, who was the helm of this institution that played a pivotal role in promoting legal education in the state of Kerala since 1966. Before we hit the crux of this session, we would like to extend our heartfelt gratitude to each and every participant who are with us through all these sessions, bolstering each passing session with their presence and support. This seminar has already ignited and strengthened the desires of law enthusiasts and budding legal eagles all over the country. We were accompanied by researchers from different strata of both the science and law field, ranging from students to scholars, providing us with a vast array of research materials, giving us an extensive understanding about the importance of forensic science in the field of law and in the field of investigation. The task of modern educator is not to cut down jungles, but to irrigate deserts. This indeed adheres to Srimati Priya MK, Assistant Professor, Kerala Law Academy, who is one among our dedicated class of faculties, who does everything with underlying kindness, love, and passion. Ma'am, I invite you for officially welcoming our guest into this session. Ma'am, please.
Thank you, Jithan. A delighted evening to one and all. Respected dignitaries, faculty members, delegates, and participants. It's a matter of pride and privilege to welcome the legal dignitaries who have gathered here to take part in the valedictory session of the 10th International Conference on Credibility of Evidence by Forensic Practices in Crime Investigation, organized by the Kerala Law Academy Law College. Forensic science helps in the application of scientific techniques to provide objective and circumstantial evidence. I consider it as a great privilege to deliver the welcome address. I'm immensely privileged to invite Dr. P. Sachidanandan sir, Kerala Police Department, HOD Forensic Science. After graduating with MSc in Chemistry from Victoria College, Palakkad, he did his PhD in Peptide Chemistry from Rajiv Gandhi Center for Biotechnology. He also holds an undergraduate in law from University of Kerala. We are extremely honored to have you, sir, with us virtually on this occasion. I welcome you, sir. I also would like to invite Dr. Beulah Shekhar, ma'am, Emeritus Professor, Department of Criminology, Karunya Institute of Technology, Coimbatore. Ma'am is involved in training of police and the judiciary in the concepts of victimology. Ma'am has also completed 5 major projects funded by University Grants Commission, Indian Council of Social Science Research, Bureau of Police Research and Development, and United Kingdom India Education Research Initiative, and coordinated funded skill-based training programs for the criminal justice. We are extremely delighted, ma'am, to have you with us virtually on this occasion. I would like to take this opportunity to extend my heartfelt welcome to Sri Nagaraj Narayan sir, Director of Kerala Law Academy, Advocate High Court of Kerala, Special Government Pleader Forest High Court of Kerala, Chairman of Kerala Law Academy Moodco Society, Member Bar Council of Kerala, teacher and mentor. I welcome you, sir. Professor Harindran K, a principal. He is a celebrated professor, a person of intelligence and wit. I welcome you, sir. Professor K. Anil Kumar, Professor, Kerala Law Academy. He's an efficient organizer, mentor, a constant motivator to the teachers, students, and everyone in and around the college. I welcome you, sir, to this event. I would also welcome Srimati Ajita Nair L, Associate Professor, Kerala Law Academy, convener of the seminar, Dr. Dakshina Saraswati, Assistant Professor, Kerala Law Academy, Srimati Shalini AP, Assistant Professor, Kerala Law Academy. Last but not the least, I would like to welcome all the faculties, delegates, participants from various universities and colleges who have joined us for the seminar. Thank you.
Thank you. Thank you so much, ma'am, for such a warm welcome. I take this opportunity to welcome you too into the seminar. A candle never loses any of its light by lighting up another candle. Taking our evening further and to begin with the valedictory session, I would like to introduce Dr. P. Sachidanandan, MSc, PhD, LLB, Forensic Science Laboratory Joint Director, HOD Forensic Science. After graduating with MSc in Chemistry from Victoria College, Palakkad, he did his PhD in peptide chemistry from Rajiv Gandhi Center for Biotechnology. He also holds an undergraduate in law from University of Kerala. Sir, I cordially invite you to deliver the valedictory address. So please.
Thank you, Jitin, for the nice words of introduction. Respected keynote speaker, Dr. Veloz Shekhar, ma'am, the faculties of the Kerala Law Academy and other dignitaries and dear students, good evening, a warm good evening to all of you. See, I am very happy to be with you in this valedictory session of the seminar because of two reasons. The first reason is I am an alumni of that college. I studied my undergraduation in law in LLB evening course during 2007-2010. I can recognize two teachers, my two teachers from the brochure. G. Anil sir, Professor G. Anil sir and Ajita madam, I can recognize them. Then the second thing for my pleasure is the subject is related to is forensic science and law because it is my profession now. So the term forensic science, as all of you know, is the application of scientific knowledge to answer the legal problems. And the forensic science encompasses a broad range of disciplines. It is not like physics, chemistry, or biology. It is a single science, but this forensic science encompasses a broad range of disciplines, which includes all branches of science like physics, chemistry, ballistics, DNA, narcotics, and so on. Therefore, unlike the other sciences, the forensic science exhibit wide variability with regard to the techniques, methodologies, and reliability, and also the level of error, the research, published materials, then and general acceptability also. So there are a lot of things in forensic science, unlike the other branches. So it ranges from the laboratory-based disciplines that gives results. For example, if you analyze a sample, it gives a result. But if you analyze a fingerprint, it is an interpretation. If it is a forged document, it is an interpretation of pattern, vehicle patterns, interpretation of writings, interpretation of signatures, interpretation of fingerprints, and so on. So the results are there, the opinion. So forensic science applies to a broad array of activities with the recognition of some of these activities might not have well-developed research base. That also we must take into account. Because some of the activities, some of the things that we are followed in the name forensic science that you can see in the movies and all, they do not have the scientific backings. And they are not developed within the culture of science. So we can see many YouTube scientists and many literature in the WhatsApp and Telegram universities that these kind of things. And unfortunately, the lawyers and judges, even judicial officers, are poorly sensitized, and the public also, they are poorly sensitized about the potential use and the abuse of such science. So now even you can watch in many movies about many techniques that used for establishing the commission of a crime and all. They do not have any scientific background, and many of them are only pseudo-science. That one must understand. So the greatest dilemma of law is the heavy reliance on forensic science, forensic evidence. Now we are more relying on the scientific evidence. And as all of you know, the cardinal rules of admissibility of evidence before court is relevancy and reliability. So for admissibility, the very important questions that underlie are the extent to which a particular forensic discipline is founded on a reliable scientific methodology that accurately analyzes the evidence and report its findings. So that is the first thing. Then second thing is the extent to which the scientists in a particular discipline rely on human interpretation, because human interpretation means there can be error, there can be some bias, or there may be the absence of a sound operational procedure, or maybe an absence of robust performance standards, etc. So these questions are very significant, and the level of accuracy in a forensic result is a key determinant of its ultimate probative value. So that must be taken into account. Then how a forensics report should be. A forensic report must be complete. It must be thorough, and it must contain minimum methods, materials, procedures, results, and conclusion. And it should also incorporate the magnitude of uncertainty in procedure, then even in the chemicals, and the level of confidence in the result. So that should be included in a forensic report. And the report should provide sufficient detail to enable any person in the courtroom or in the courtroom participant who can understand, and if required, he can question the procedures, the sampling methods, the analysis, the interpretation, its limitation, etc. And the report should be free from the technical jargons. The forensic report should not have technical words, or minimum, it should be free, or it should have minimum technical words. For example, DNA, we cannot avoid the word DNA, so we can add that in the report. So otherwise, it should not have any technical jargons. Now, coming to the type of reports, if you go through the reports, you can see that there are two types of reports. One report is opinion, and the other one is result. So let us see what is the difference. Opinion means, for example, I am collecting a fingerprint from a place of occurrence, a place where the crime has occurred, and I got a fingerprint. Then later, an accused, the police caught a person, and his fingerprint is matched with the fingerprint in my hand. So I am comparing it. So simply it is an interpretation. It is a comparison based on certain points. Since it is a comparison, there is every chance for error and bias. So the fingerprint report is not a result, but it is an opinion only. And please remember that opinion evidence is only an advisory evidence. The Honorable Supreme Court in Dayal Singh versus State of Uttarakhand held that the expert opinion is primarily to assist the court in arriving at a conclusion, and it cannot form a sole basic of conviction. And in another case, the court held that the opinion of expert should be respected, but not worshipped. That is very, very important. I have seen that in several instances, either it is worship or it is brushed aside. It is actually not tested in the court, mainly due to the lack of sensitization among the lawyers and judicial officers. So in some cases also, I have seen that even the lawyers they themselves form an opinion, and expert opinion. There is also another citation, another quote from the Honorable Supreme Court, that expert opinion by a court is dangerous. In Virpal Singh versus Secretary, Ministry of Defense, the court held in that way. So it should be kept in mind that opinion evidence should be taken, should be accepted with caution, and it should be substantiated with enough statistical data. And in the absence of such as statistical data, the conclusion based on such opinion is only a leap of faith. That must be in mind. But the results are different. Result means, so for example, a drug was caught from a drug peddler, and that drug is sent to analysis to a forensic science laboratory. The scientist analyzes it, and he found that it is a contraband drug, say ganja or say cocaine. And that result is final result. If the expert had done his examination by approved test methods, then that result is a final result, and it cannot be questioned. If the drug is analyzed in any other laboratory by any other expert, the result will be the same. But opinion is not like that. Opinion can change from expert to expert. But so these are the difference between the opinion and results, which many people are not taking into account. So that is why I said this here. Then we are relying, the courts are relying on scientific evidence. And the advantage of scientific evidence is it is a concrete and conclusive evidence. In the last days of the seminar, you might have heard about from many speakers with a forensic background and also legal backgrounds about the conclusiveness of the forensic evidence. It is very concrete evidence, and it is very conclusive, and it will never go away along with the witness. The evidence will not go. If the witness dies, the oral evidence goes, but scientific evidence will never go. And that evidence cannot be twisted, or it cannot be turned hostile, and that cannot be forgotten. So these are the advantages. So, but the only thing is, the lawyers and judges should understand the advantages and limitations of forensic science. So for this, what we have to do is a lawyer should be properly trained to understand the principles of forensic science. They should be properly trained how to examine an expert witness. That is very, very important. Unlike the routine cross-examination that you are learning during our moot court, that in that one, we should also include the cross-examination of expert witness also. The expert witness should be questioned based on his report, his test procedures, etc., and not the procedural lapse and all. So, unlike the routine cross-examination, he should be allowed to explain his answer. Otherwise, if he is not allowed to explain his answer, there are two issues. One, his efforts that put for the analysis of a crucial piece of evidence will be gone a waste. It will be brushed aside. The second thing is, all this will ultimately lead to the miscarriage of justice, and that should not be happen. So these things should be kept in mind of each lawyer and each judicial officer and each person who is indulging with who is handling these legal things. So now we will go to the Indian scenario. See, when we come to the Indian scenario, in India, the forensic science is still developing. It is just in the beginning stage. Though there are forensic science laboratories in everywhere in the country. We have about 10 central forensic science laboratories and many state forensic science laboratories. Each state has its own forensic science laboratory. In Kerala scenario, we can see there is one state lab at Trivandrum, then 3 regional labs in 3 police ranges, and even district labs. So all this we have there, but when you go through the forensic science setup all over India, one can see that they lack adequate manpower, and the existing manpower is either poorly motivated or poorly paid, and they are not satisfied with the existing setup. So all these things is there in the country. So because of that, many people think that forensic science thing is not properly working. But the problem is their problems are not properly addressed. This is their scenario in everywhere in the country. And most of the countries, in most of the countries except the developed countries, this is the situation, and forensic science is a neglected subject. So there, then you go to the status of the forensic scientist also, you can see that they are not in par with the other scientists who are working in the research organization and all. They are below that. Only because the main reason is their concerns are not properly addressed, and they are not under a regulatory body, and it lacks necessary governance and structure to pull itself from the weakness. Now the government of India had started a National Forensic Science University at New Delhi and Gujarat. So let us see. I think that is which will develop in the future, and it will address the problems in the area of forensic science. A problem in forensic science means it is a problem in the judicial system also. Now towards improving the quality of delivering justice, what we should have. We must have a good system of forensic science regulatory body under which bright and qualified scientists working as expert to support the justice delivery system. Now you can see that there are a lot of universities and colleges mushrooming with forensic science courses, but most of them I say, do not have the basic infrastructure and facilities. But after watching the movies, like the English movies, the crime thrillers, and even the Malayalam movies like Forensic, Sanjam Padre, etc., the bright students are running behind such courses. And unfortunately, they end up in miseries. I know many students who studied forensic science and they are now waiting for some job. So this is a issue faced in India by students. So, but on the other side, we lack qualified scientists also. Then second thing is now in India, forensic science laboratories are a part of the law enforcement agencies like police. It should be independent. It is not. It should not be a part of the law enforcement agency. That is another issue. Then the certification and accreditation of the laboratories, that should be made mandatory, because as if I am a forensic scientist and I am going to a court and telling something in the expert testimony, only because I am this person is a scientist, his report should be accepted. No, that should not happen. But it is happening in many places. So each forensic scientist and each forensic science laboratory should be properly certified, and no person, whether it is public or private, public in the sense government or private, should be allowed to practice in forensic science discipline or testify forensic science professional without certification. Just like a doctor, each person should be properly certified. Then only their report should be considered before court. Certified reports from certified labs by the certified expert shall be made acceptable as evidence. For this, there should be lawyers familiar with the scientific principles who can effectively conduct the testimony of expert witness. And there shall be judicial officers with good knowledge about the advantages and limitations of science, so that they can recognize such evidence and can reach upon a final conclusion in criminal prosecution as well as in civil litigations without worshipping the scientific evidence. That is what our Honorable Supreme Court said. For this purpose, my suggestion is at least one paper in forensic science should be included in the undergraduate syllabus of law, that is in the LLB syllabus, as a mandatory subject. One paper should be there. I don't know whether it is there at present. I think it in some universities they have included. Then lastly, but not least, I would like to congratulate the organizers of this seminar for choosing this subject, since it is a need of the hour. Let it be a beginning of the sensitization process. And still, I remind you that we have miles to go before sleeping. So once again, thank you very much for inviting me to this program and for your patient listening. Jai Hind.
Thank you so much, sir, for your profound words. Now we are blessed with the presence of Dr. Beulah Shekhar. She is the Emeritus Professor of Criminology. Her responsibilities include teaching, research, and extension activities with special focus on collaborative research. She was formerly the professor and the head of the Department of Criminology and Criminal Justice Sciences. She was awarded the prestigious Indo-Hungarian Fellowship in 2010, and she is also the recipient of the Commonwealth Academic Staff Fellowship 2013-14. Ma'am, it's a matter of great privilege and honor in welcoming you to address this session. Ma'am, please. Pardon, pardon us as we are facing some kind of technical issues. As ma'am, it could not be, the session could not be made available for ma'am due to some technical issues. Pardon.
Hello. Can you hear me?
Yes, ma'am, you're audible, ma'am.
Okay. I lost the video, but is it my turn now?
Yes, ma'am.
Has
Yes,
Professor Satyanandan finished?
yes, ma'am.
Okay. So I'm in Kunnur right now and it's raining. So the bandwidth is not very good. I hope I can go through this without any hiccups.
Sure.
And I'm sorry that I will not be able to turn on my video also. So let me begin by thanking the organizers for this conceptualizing of this very pertinent talk, very, very relevant today. And I congratulate the organizers and thank you for this opportunity to share my ideas with you. I was fortunate to hear Dr. Satyanandan also. So what I would do today is, I think you had a overdose of a lot of things said today. There were many very full sessions on this. So I will just try to touch upon the marsh of scientific evidence, so to say. When I say marshalling of scientific evidence, I would talk about its science credibility, its validity, its accuracy, its relevancy, its admissibility, its precision, and its tenability. And I would do this in reference to the landmark judgments we have in India today. So like we all know, we are all students of law, and law is dynamic, and I would say organism that evolves a way of accommodating new scientific technology. And with the onset of a lot of scientific, which helps in removing the ambiguity law is able to imbibe within its scope the scientific applications of forensic science evidence in many areas, and some would be the digital forensics, the forensic science and the right to privacy, forensic DNA, forensic ballistics, forensic biology, and forensic toxicology. So looking at all this comes under the large umbrella of forensic science. Forensic science, according to F.E. Camps, is laws of nature, laws of man. So that's this forensic science is doing. And here I would like to share that I am a student of Professor Chandrasekhar. He was the director, the late Professor Chandrasekhar. He passed away a year ago. So I was his student. He was a director of the forensic science laboratory in Chennai, and he was the one who cracked the Rajiv Gandhi assassination case within 24 hours and made it known that it was a belt bomb that killed him. So his definition is also talking about forensic science as the conglomeration of all bits of human knowledge, experience, and endeavor, which are used as fact-finding tools for all legal requirements. So this is what this forensic evidence is trying to do. And we need to marshal it correctly. We need to steer it correctly. And we need to use this evidence very judiciously. So, and this evidence brought us by this testimony where in case there is no conclusion, evidence, and we have to draw from the opinion of witness experts. And this comes under Section 45 of the Indian Evidence Act. So it's a kind of a written report which includes the basic information related to evidence. It includes a conclusion and opinion as well. And it includes also, very importantly, the valid reason for supporting the opinion to the fact of the case. So these are the various things that are included in these expert testimonies. So you see, there is a lot of sanctity with this. And we have the Indian Evidence Act, Section 45, which defines an expert. And this expert is referred to that person who has a special set of knowledge or skills in a particular field, and he brings the testimony to the court. So we see that law without justice is wound without cure. And to provide justice, we need to rely heavily on this scientific evidence today. So we have the Indian Evidence Act, Section 45 to Section 51, which talks about relevancy in different evidence matters, relevancy of the opinion of experts, opinion of examiner of electronic device, and bearing upon the opinion of experts, the opinion as to handwriting and usages and tenants, and all of these already talk about. And then we have the CRPC, Section 293, which deals with the admissibility of the expert opinion. And also we have our Constitution, which in Article 23 protects against self-incrimination and holds good the legal maxim niminitor prodeur accuser ipsum. So this also is a production.
Pardon for the difficulties as ma'am is facing some. Ma'am?
Can you hear me now?
Yes, ma'am. Yes, sure, ma'am.
Okay. So then we have the CRPC also, Section 161(2), which also talks about right against self-incrimination. So all these things happen when we talk about collection of evidence and presentation of evidence and administration of this evidence in investigation. So investigation itself, when you define investigation section 2 of the CRPC, you say that it says it is related to collection of evidence. So this is the most important thing when you talk about collections, and that is why it has to be done and presented with sanctity. So this So the mistake I see that we make in India is we do arrest first and investigate later, whereas arrest should be the last stage of the investigation after all the evidence is collected, and then comes the arrest. So this is where there is a lot of abuse of power happening because of the investigation that follows the arrest, when it should stage of the investigation after collection of all the possible evidence. So I would say that the evidence is, when you classify it into 5 types, the intuition, personal experience, testimonial, anecdotal, of all the scientific evidence, most important, it is supreme, because science can never lie. Science can never alter the truth, and it is never biased. So this scientific So like we heard the speaker before me saying that there are a lot of things that are not done very correctly in the Indian scenario. And maybe this is what led to the judgment in Selvi versus State of Karnataka, when on 5th March 2010, a landmark judgment was given, and they had swept out all this type of, the judgment rendered that the practice of tests to be unconstitutional and void, as they are violative of the accused person's right against self-incrimination. So this is attributed to many of the non-judicious use of these kinds of scientific evidence. So even after this judgment came, we had that for the past decade or so, I would say from 2001 onwards, there was indeed a black period for crime investigation and criminal justice administration in this country. So that is what gave rise to this judgment. But as soon as we had this judgment, we had the former CBI chief, Mr. Ashwini Kumar, who had written one of the forewords in my books. He's no longer with us. And we had the former police officer, Dr. Kiran Bedi, who wanted the Supreme Court to revoke this ban. And their contention very rightly said that it is the police, the contention was that the police investigation will be very much hampered without these truth detecting techniques. So we see how carefully it should be used to avoid throwing the baby out with the bathwater, is what happened in this case of Selvi versus State of Karnataka. So we see in the digital forensics, there are many, many judgments passed by the Supreme Court, wherein the scope, application, and admissibility of electronic evidence are discussed. We have many cases like the R.M. Malkani versus State of Maharashtra, Ziauddin Bukhari versus Brijmohan Ramdas, then Dharamveer versus CBI, Jagat Singh versus State of Haryana. So we have many, many principles laid down. In the case of Ram Singh versus Colonel Ram Singh, we have that Apex Court has laid down principles regarding admissibility of tape recordings, the voice of the person against whom such recording is being produced as evidence must be duly identified by the person who's producing such recording evidence. So you see how the courts have marshaled this kind of scientific evidence and try to preserve the use of this and try to encourage the presentation of scientific evidence in the courts of law. And then we have the forensic science and the right to privacy. Here again, there are many case laws. I would encourage all the students to have a look at a document produced by the NICFS in Delhi, in which they have compiled all the honorable Supreme Court judgments which talk about science as a tool for justice delivery. This is a very pertinent document, and this institute now comes under the National Forensic Science University, which Dr. Satyanandan was talking about. So we see that identification by DNA tests, be it in the Nirbhaya case or in this Dharam Dio case, and where in this particular case, they had identified the body of Italian woman who was murdered using the DNA sample of the father's blood and comparing it with this skeleton. And the conviction was based mainly on the fact that the body was identified as that of Diana, who was murdered in this case. So you see forensic ballistics as well. There's so many judgments. Kalua versus state of UP, Mohan Singh versus state of Punjab, and Ramnath versus state of Tamil Nadu. Supreme Court held that it would not be justified in rejecting the opinion of an expert who has examined the markings under comparison microscope, simply for the reason that he did not think it necessary to take the photographs. So you see how courts have been steering this scientific evidence to achieve justice. We have forensic biology again, where Kamaljit Singh versus state of Punjab, Dayal Singh versus state of Uttarakhand, which the previous speaker also referred to. So the courts normally look at expert evidence with a greater sense of acceptability. But it's equally true that the courts are not absolutely guided by the report of the experts. So there is a line that they draw, and not always to be in favor of the accused or throw out the evidence saying it was not proved beyond reasonable doubt. Similarly, in forensic toxicology also, the NDPS Act, so many cases, state of Rajasthan versus Jainuddin Sheikh, Harjit Singh versus state of Punjab. So here again, the FSL reports provide for potency of the opium, giving particulars of the morphine content. So there are situations in which in all these different branches that we spoke about, we have very proactive judgments, very victim-friendly judgments as well. So here, when you look at the role of researchers, the role of academicians, the role of scientists, so we see that these judges, when they marshal this scientific evidence into the court of law, we see that they are the gatekeepers of the sanctity, of the credibility, of the validity, of the accuracy, of the relevancy, of the admissibility, of the precision, of the tenability of evidence, and the acceptance of the witness as the expert within their own courtrooms. So we see how important the role of judicial officers is in this case. So we as academicians, as researchers, as scientists, I think we should calculate estimates of the degree of validity and reliability for the forensics comparison system under conditions as closely matched as possible to the conditions of the case at trial. So this is what we can do. We can do our research and prove the validity and the reliability. This would help the judicial officers in their work as well. So these estimates of validity and reliability, they should be presented to the judges. And this would allow the judges to make a rational decision as to whether the scientific and the procedures have been demonstrated to be of sufficient validity and reliability. So this is a very important part of what you have as a title of your workshop today, the credibility of scientific evidence. So you see, even if the judicial system does not require forensic scientists to present measures of validity and reliability, this would still represent the best scientific practice, in my opinion. So I saw, as a Fulbright scholar, when I was in the US, I was able to witness some of the cases where scientific evidence was used. And I saw that they have something called the Fryer Standard, in which the court had to decide if the following 3 points in question were generally accepted by a meaningful proportion of the relevant scientific community. So there were three standard checklists, kind of. First of all, the procedure, how the scientific evidence was collected, the technique, and the principles underlying this. So this standard, it's called the Friar Standard, and this standard prevailed in the federal courts and many other states as well for a long time. And then we had that replaced by the Daubert Standard. And this was only used in the federal courts. And this also helped in deciding if the science and the expert in question should be permitted. And the judge was given a few checklists that he could consider, he or she could consider. One of it was, what is the basic theory? And has this theory been tested? The other one was, are there standards controlling the technique? So what are the known potential error rates? Is there general acceptance of the theory? Has it adequately accounted for the alternate explanations? Has the expert unjustifiably extrapolated an accepted premise to an unfounded conclusion? So these are the things that you need to look at as legal officers, so before you accept and you give credibility to a particular piece of scientific evidence. I think this is a very scientific way of doing it. So maybe go ahead and maybe as leaving thought and maybe some food for thought, maybe we should So maybe we should also think of establishing standards which would help the judges decide with ease with regard to all these factors like sanctity, credibility, admissibility, precision, tenability, etc. And this might bring in the much needed uniformity in decisions. We see when we look at the judgments, landmark judgments back and forth, we see that there is a lack of uniformity. So maybe if we have something like these standards, Friar Standard or the Daubert standards, maybe it would evolve out of one of the judgments to come. So this would help in taking decisions regarding the forensic evidence placed before the courts. So thank you for your attention and all the best in whatever you do. Thank you.
Thank you so much, ma'am, for lighting our minds with your valuable insight. The only time you should look back is to see how far you have come. Now, I would like to give you a sneak peek into our week's worth of hard work. Now, let's have a gander behind the curtain to see how the Cokes turned with a short behind the scenes video for our 10th international seminar. Sometimes it is just as interesting to see how the magic happens as much as the magic itself, is it not? The miracle of gratitude is that it shifts your perception to such an extent that it changes the world you see. It is a divine emotion which fills the heart, but not to bursting, but warms it, but not to fever. With that being said, let me now welcome Srimati Shalini AP, Assistant Professor, Kerala Law Academy, whose aura of optimism can always be felt by her students while engaging with her vibrant personality. Ma'am, I invite you to add the final topping to the session by delivering the vote of thanks. Ma'am, please.
Thank you, Jitin. Dr. P. Sachidanandan, Joint Director, Forensic Science Laboratory, Kerala Police Department. Dr. Beulah Shekhar, Emeritus Professor, Department of Criminology, Karunya Institute of Coimbatore. Advocate Nagaraj Narayanan, Director, Kerala Law Academy Law College. Delegates, participants from various colleges, my colleagues and my dear students. I consider it as a privilege and a pleasure to propose the vote of thanks to the dignitaries of today's valedictory function organized by Kerala Law Academy Law College along with Center for Advanced Legal Studies and Research. We have had the great opportunity to have among us Dr. P. Sachidanandan, Joint Director, Forensic Science Laboratory of the Kerala Police Department, to deliver the valedictory address of this seminar. On behalf of Kerala Law Academy, teachers, students, non-teaching staff, I propose a heartfelt thanks to you, sir. We are indeed grateful to Dr. Beulah Shekhar, Emeritus Professor, Department of Criminology at Karunya Institute of Coimbatore, who delivered the keynote address for this seminar. On behalf of Kerala Law Academy students, teachers, non-teaching staff, and on my own personal behalf, I propose my heartfelt thanks to you, ma'am. An overwhelming gratitude to Sri Nagaraj Narayanan, sir, Director of Kerala Law Academy, Advocate High Court of Kerala, Special Government Pleader for Forest High Court of Kerala, Chairman of the Kerala Law Academy Moot Court Society, Member of the Bar Council of Kerala, teacher, mentor, and always a fountain of constant support to all the activities in this college. On behalf of Kerala Law Academy, teachers, students, and all the non-teaching members, I propose a sincere thanks to you, sir. I would also like to extend my heartfelt thanks to Dr. Lakshmi P. Nair, Research Director, Center for Advanced Legal Studies, for being a constant support for all the events conducted by the college. Sri Harindran K., our principal, is always a source of inspiration to all the academic activities in this college. On behalf of Kerala Law Academy, teachers, students, and non-teaching staff, I propose a sincere thanks to you, sir. I would also like to take this opportunity to extend my sincere thanks to Sri Anil Kumar K. Sir, Professor, Kerala Law Academy, for providing his constant guidance and support throughout the event. I would also like to express my gratitude to Mrs. Ajita Nair L., convener of the seminar, and Dr. Dakshina Saraswati and Srimati Priya MK, co-conveners of this seminar, for their hard work, effort, and constant support in making this event possible. We have been fortunate enough to be backed by a team of very proactive and dedicated students of KLA for their involvement and willingness to take this completion of their task to make the seminar a reality, and a heartfelt thanks to each and every one of you. I would also like to thank everyone who has worked behind the scene to make this event a reality, and especially a very special thanks to our IT department for providing us with their technical support, which is significant due to the virtual nature of this event. And finally, I would extend my heartfelt thanks to our participants who have joined us from various parts of the country to make this seminar a grand success. Thank you.
Thank you so much, ma'am, for your benevolent words. The 10th International Seminar on Credibility of Forensic Practices in Crime Investigation reminds us about the famous quote in the Sherlock Holmes series where it is said that one should not trust the general impression, rather concentrate on the details. This is an all-pervasive one, applicable in every spheres of our life. Also, this seminar gives a platform to acquaint with the galaxy of scholars and intellectuals who share the words of wisdom, knowledge, and poured insights from different directions and fields. It is good to have an end to journey toward, but it is the journey that matters in the end. At this concluding phase of a day-long journey, I extend my heartfelt gratitude and thankfulness to all the dignitaries, personalities, lawyers, professors, and intellectuals for enriching the seminar with their esteemed presence. I would like to express my sincere gratitude towards Advocate Nagaraj Narayanan Sir, Director, Kerala Law Academy, Professor Harindran K. Sir, Principal, Kerala Law Academy, and Anil Kumar K. Sir, Professor, Kerala Law Academy. I also would like to thank our faculty conveners, Ajita Nayan Ma'am, Associate Professor, Kerala Law Academy, Dr. Dakshina Saraswati Ma'am, General Secretary, Moot Court Society, Priya M.K. Ma'am, Assistant Professor, Kerala Law Academy, and Shalini A.P. Ma'am, Assistant Professor, Kerala Law Academy. I would like to sincerely thank our student conveners for their tireless efforts for the success of this event. Last but not the least, I would like to thank each and everyone who strived tirelessly for the success of this event, because this would have not been possible without their sincere efforts. As we have reached the end of this valedictory session, I request everyone to kindly rise for our national anthem. A good event never ends. It takes only a pause and keeps us awaiting for the next. Thank you so much. I wish each one of you with the best wishes for all your future endeavors. On behalf of Kerala Law Academy, Law College, it was indeed a great privilege to host this valedictory session. This is Jitin SB, and I wish you all a great night, great evening ahead. Thank you all.